Welcome everyone to our webinar on Disputes 101, how to prevent and manage commercial contract disputes. My name is Kathryn and I'm a practice leader in LegalVision's commercial contracts team. I'm joined today by my colleague Rebecca, who is a practice group leader in our disputes team. Before we begin, a couple of quick housekeeping items. You'll receive the recording of this webinar and the slides in your email at the end of the webinar. Please submit your questions in the chat box and we will answer them at the end. And we would be grateful if you could please complete the feedback survey after the webinar. Also, all attendees are eligible to receive a free consultation with us to discuss how we can help you with your contracts or any of your other legal needs. To request your free consultation, provide us with your contact details in the survey that appears at the end of this webinar. So, today we will be discussing understanding contract disputes, the importance of clear contract language, current legislation, what to do when things go wrong, and then at the end, we will be answering some of your questions. Please submit your questions throughout the webinar through the chat function, and we will answer them at the end. So, what is a commercial contract? A commercial contract is a legally binding agreement between two or more parties engaged in business activities. These contracts outline the terms and conditions that govern the relationship between the parties involved. They set out key matters such as the obligations and responsibilities of each party and how any liability is to be apportioned. Commercial contracts are used across a broad and diverse range of industries and can vary significantly depending on the industry, purpose, and the complexity of the arrangements. Rebecca will now talk about some of the causes of contract disputes.
Thanks, Kathryn. Commercial disputes can arise for various reasons, and they can be complex and often costly to resolve. From our experience at LegalVision, the typical causes of commercial contract disputes typically include breach of contract. So firstly, where one of the parties has not held up their end of the deal. So for example, there's been a non-delivery of goods or services or a failure to meet particular KPIs or other specified terms in a contract. Secondly, ambiguous or unclear contract terms. In my experience, many disputes arise because there has been either no written contract or the contract has been poorly drafted, which means that particular terms or obligations have been interpreted differently by the parties, which has led to a dispute. Misrepresentation, where one party misrepresents particular facts or situations during the contract negotiation, a party might feel that it's been led into a contractual arrangement on false grounds. So that party might have some particular basis to challenge the contract validity. Change in circumstances. Commercial relationships change over time, and this can be due to market shifts or economic conditions or a change in business strategy. This can lead to disputes over contract terms where one party feels that the contract doesn't represent the position of the parties anymore. Disagreements over payment terms. Issues related to payment schedules, pricing, or invoicing can result in contract disputes, particularly in long-term contractual arrangements. Finally, termination disputes, where one party seeks to terminate the contract prematurely or without proper justification. The parties can get into a fairly complex dispute. Now, Kathryn can talk to us about the importance of having a well-drafted contract.
Thanks, Rebecca. To minimise the risk of contract disputes, it is crucial to draft clear and comprehensive contracts and ensure both parties fully understand their obligations and rights before entering into the contract. When drafting a contract, it is essential to ensure that the contract is clear, enforceable, and protects the interests of all parties involved. While contracts can vary depending on the specific transaction or arrangement, some key terms that should be included in most contracts are as follows. Identification of the parties. Clearly identify the parties entering into the contract, including their legal names and contact details. Purpose and scope. Clearly state the purpose of the contract and specify the scope of the goods, services, or obligations involved. Deliverables and performance. Describe in detail the goods or services to be provided by each party, and the standards by which their performance will be evaluated. Specify the terms and conditions under which the contract will be executed, including any performance milestones, timelines, or deadlines. Consideration. This is the exchange of value. Outline the value to be exchanged between the parties. This could be money, goods, services, or a combination. Payment terms. Clearly state the payment terms, including the amount, currency, method of payment, due dates, and any applicable penalties for late payments. Confidentiality. Commercial contracts or commercial arrangements often involve the exchange of sensitive commercial information between parties, so it is important to include provisions to protect sensitive information and trade secrets from being disclosed to third parties. Intellectual property rights. Clearly outline who owns what intellectual property, how it may be used, and who will own any new intellectual property created in the course of the commercial relationship. Termination and remedies. Include provisions outlining the circumstances under which the contract can be terminated and the remedies available in case of breach by a party. Liability. Apportion the responsibilities or aspects of the arrangement that each party is liable for and include any commercially appropriate indemnities or liability caps. Dispute resolution. Common dispute resolution methods are negotiation, mediation, or arbitration, or a combination of all or some of these. The dispute resolution method used will depend on the dispute resolution clause in your commercial contract if it has one. The severity of the dispute will also be a factor. It is important to specify in the dispute resolution clause in the contract the mechanism or process for resolving a dispute if it arises. It is quite common to see a negotiation be the first step, followed by mediation or arbitration before litigation is then an option for the parties. However, this does not generally apply where there is an urgent need for a party to go to court to get an injunction. Governing law and jurisdiction. Indicate the laws and jurisdiction that will govern the interpretation and enforcement of the contract. It is really important that the parties are able to know what law of what country will apply should a dispute arise. Force majeure. Include a clause that addresses unforeseen events or circumstances that are beyond the party's control and which may excuse non-performance or a delay in performance. Amendments and modifications. Specify the procedure for making changes or amendments to the contract and any requirements for written consent. Assignment. Determine whether the parties can transfer their rights under the contract to third parties. An entire agreement clause. This is a useful provision which states that the contract represents the entire agreement between the parties and supersedes any prior or contemporaneous agreements or understandings, such as email correspondence. Severability. Specify that if any provision of the contract is found to be invalid or unenforceable, the rest of the contract remains in effect. Turning now to the legislation. In New Zealand, contracts are primarily governed by the Contract and Commercial Law Act 2017. This Act provides a comprehensive framework for contract formation, interpretation, and enforcement. The Fair Trading Act 1986 is also relevant. In terms of contract disputes, the Contract and Commercial Law Act provides remedies and damages. So the Act clarifies the rules regarding remedies for breaches of contract, including damages, specific performance, and injunctions, as well as default interest. It provides that in relation to the sale of goods, interest can be charged on any amounts overdue for payment without prejudice to a claim for damages for breach of contract. Enforcement. The Act outlines various mechanisms for enforcement of breaches of contract. In terms of contract disputes, the Fair Trading Act provides unfair contract terms provisions. It enhances protections for consumers and businesses that are parties to standard form small trade contracts by setting out rules for unfair contract terms and an avenue for complaint if a contract term is unfair. It also covers unconscionable conduct. The Act prohibits unconscionable conduct in connection with contracts, offering safeguards against exploitation or abuse in commercial transactions. Rebecca will now speak about what to do when things go wrong.
Thanks, Kathryn. First, it's important to acknowledge that disputes just happen, and businesses, would be most businesses will find themselves in a dispute at some point. Now, disputes can come in all shapes and sizes. They can be big, they can be minor, but generally, trying to resolve a commercial dispute in relation to a contract will follow kind of this same process or formula that I'll outline. So, firstly, we always recommend taking a good faith approach in the beginning. So before you come in all guns a-blazing and threatening court action, communicate and negotiate. It's important to put everything in writing and take notes after phone calls or meetings where you might be trying to informally resolve the dispute. Now, creating a document trail is really important if you need to go to court later. It also makes sure that both parties are on the same page about what is going on. So we often recommend to our clients, if they have a phone conversation with a party from the other side of the contract, where they're trying to talk about a particular issue or come to an agreement, best practice would be to then send an email saying, we had a meeting on this date, we discussed the following things, list them in a bullet point. If you don't agree, with the summary of the above, please let me know, where we're at in terms of that difference. It's really important to make sure that you've got that document trail and to make sure that everyone's on the same page to avoid further disputes. Now, as Kathryn outlined before, your contracts, if you've got a written contract, might provide some form of framework for dispute resolution. So it's important to have a look to see if there are particular obligations that you need to comply with in a dispute in terms of providing notices or attending some form of mediation or arbitration before commencing proceedings. When you're dealing with a dispute, it's important to try and narrow the issues in the dispute. So instead of trying to focus on every single little thing that's gone wrong in a commercial relationship, focus on the big ticket items that are making the most impact to your business and be clear about what the dispute is really about. Look out for organisations or bodies that might be able to assist with your particular dispute. For example, there are a number of commercial bodies that offer mediation services, which is a great option if you want to try and resolve a dispute yourself. Get some legal advice. Now, I'm not just trying to spruik our own services here, but it's important to understand your legal position, what your options are, and get advice on strategy. Now, legal representation can occur in many different ways, and it will be important for you to let your legal representatives know what the personalities that you are dealing with are like, whether or not calling in the lawyers is actually going to be helpful or a hindrance to trying to resolve the dispute. And so if you think that calling in the lawyers is not going to be helpful because you want to preserve your commercial relationship in the long run, it might be that your lawyers can be operating behind the scenes, ghostwriting emails for you, advising you on strategy, but that you are actually the face-to-face contact with the other side. The other advantage of getting lawyers involved is that we like to look at problems and try and solve them and we look at them in a really abstract way. To us, a dispute is just a problem that needs to be solved. We'll be completely detached from the emotion and the stress of the matter. And in some ways, a lawyer will act as your shield, to try and deflect some of that stress so that you can focus on your core business objectives. So how can you resolve a dispute without going to court? Firstly, start negotiating. Send a letter that sets out your position. Now, this is always going to be the first step when you engage a lawyer. When we have a client that comes to us with a contract dispute, the first thing that we do is prepare a letter that sets out the key terms of the contract, the issues in dispute, the relevant background, what's happened, and we put the position of our client at its very highest. And then what we try to do is engage in an exchange of information. So we want the other side to the contract dispute to see the dispute from your perspective, understand your position, and then also understand the risks if they can't resolve it. If you have a lawyer giving you some advice, they might talk to you about the advantages of sending correspondence on an open basis and correspondence on a without prejudice basis. I'm just going to quickly run through what this means. Open correspondence is communications that are not protected by the without prejudice privilege, and these communications are admissible in court and can be used as evidence in legal proceedings. So it's important to be aware that any emails, letters, or even a record of the telephone conversations that you're having with the other party to the dispute could ultimately be used as evidence if the dispute can't be resolved and needs to go to court. So, when a lawyer writes a letter, in the back of our mind, we are always writing a letter with a secondary reader in mind, and that's generally the court. We always want to put things forward in a way that puts your position at its highest if it's ever going to be scrutinised by a third party. So open correspondence would be typically used to where you're trying to put your position at its highest, put evidence forward, and all of the things that you would want the court to see should it eventuate in court proceedings. Now, without prejudice correspondence is slightly different, and we would use without prejudice privilege to protect communications between the parties that are made during a negotiation or discussions aimed at settling a dispute. Now, these communications are generally considered confidential and not admissible in court proceedings unless the parties agree to waive without prejudice privilege. Now, the purpose of a without prejudice correspondence is to create a safe environment for the parties to negotiate freely without fear that their statements or concessions can be used against them in court. And it encourages open and honest discussions when trying to reach a resolution. Now, it's important to understand that you can't just simply mark things without prejudice. There needs to be a genuine attempt to compromise on your position for a document to be considered without prejudice. It's often a very strategic decision as to when to issue without prejudice correspondence and open correspondence and what to put in both types of these correspondence. And there may be times where you actually send letters parallel, one that's an open correspondence and one that's a without prejudice letter at the same time. These are all things that a legal advisor can assist you. Now, once there's been a bit of a trial by correspondence, hopefully not too much, the parties might agree to negotiate, and that might take place in an informal settlement conversation, discussions, or a mediator might get involved and conduct a more formal structured mediation. Now, the purpose of this phase is simply maybe to agree to disagree. It might be worthwhile trying to compromise to get your commercial relationship back on track. If you can reach an agreement, a settlement deed will be prepared that will evidence the agreements of the parties to avoid any further dispute. And ultimately, if you can't agree to disagree or compromise, then court action might not be your only option. So when we're talking about exploring the options for negotiation or mediation, we generally refer these as alternative dispute resolution options. So I'm just going to explore some of these options. Now, generally ADR processes, which would include mediation or arbitration, are generally less expensive than going to court. Legal fees, court costs, and the time spent in lengthy litigation can be significantly reduced by using ADR processes. ADR processes generally resolve a dispute much quicker than the court system, and this can be really important for businesses looking for speedy resolutions so they can get on with the core business objectives. ADR processes can often take a more flexible and adaptable outcomes than traditional litigation, and parties can tailor the process to their specific needs and concerns. Another advantage of ADR is that it can help preserve relationships. It often emphasises cooperative problem solving, and where the parties can try and reach a compromise together, that can lead to a better ongoing commercial relationship in the future. ADR processes also tend to be less adversarial than traditional litigation models. So this can reduce the hostility and emotional stress for the parties involved. Parties involved in a dispute also have greater control over the outcome in ADR. They can actively participate in the resolution process and work together to find a mutually acceptable solution. And that solution might often be something that would generally not be imposed by the courts. So ADR options include mediation. Mediation is a process whereby a person will be agreed to act as sort of an independent referee that will try and help the parties see each other's position and reach some sort of resolution, or an arbitration. Arbitration is a bit more like a court system. You'll have an independent person, but they act more like a judge. The parties will present their position, and then they will reach a decision, and that decision is often binding, which is also a key point of difference from a mediation. So what happens if you can't solve it yourself and you need to go to court? Litigation processes involve formal resolution of disputes through the court system and generally take place in the following key phases. Firstly, what is referred to as pleadings or court documents. So the process will typically begin with one party filing a court document that outlines the basis of their legal complaint. Then the other party has the opportunity to file a response. These are both very complex documents, and I would generally recommend getting a lawyer's assistance to help prepare these documents. Once those documents are filed, the next major phase of the litigation process will be exchange of evidence and other pretrial procedures. Once evidence has been exchanged, the courts will generally require the parties to attend a mediation to see if they can't resolve the problem before then the final stage, which is a hearing. At trial, both parties will present their arguments and evidence, and the judge will come to a conclusion. If the parties are dissatisfied with the outcome, then there may be an opportunity to pursue an appeal through a higher court. Now, litigation is certainly a process that doesn't lend itself well for people to try and self-represent, because it's so formal and the courts adhere to established rules of evidence and procedures. Generally speaking, you need to get a lawyer involved, which is why litigation is generally a more time-consuming and costly process, and why it's very much worthwhile trying to explore ADR processes. Litigation can also take 6 to 12 months or longer to even get to a hearing, and then you need to wait for a decision, again, which could be subject to appeal. So your commercial dispute could be locked up without an outcome for a very long time. And ultimately, courts will still try and encourage you to settle it yourself and explore a compromise at a mediation. And in my experience, 90% of matters will generally resolve before getting to a trial. So it's worthwhile trying to see if you can reach that resolution sooner rather than later. Now, Kathryn is just going to summarise some of the key takeaways for trying to prevent disputes.
Thanks, Rebecca. So what are some things you can do to avoid disputes? Regularly review your business documents and agreements. As set out above, contracts should specify the rights, obligations, and responsibilities of all parties involved, including terms of payment, delivery, performance, and dispute resolution mechanisms. Open communication. It is important to maintain open and transparent communication with all parties involved in your business transactions. Address concerns and issues promptly to prevent misunderstandings escalating into disputes. Risk assessment. Get legal advice before you sign documents. A risk assessment should be undertaken to ensure you understand what you are agreeing to and that you are prepared if things go wrong. Document everything. Don't rely on a handshake deal. Maintain accurate records of all transactions, communications, and agreements. Detailed documentation can serve as evidence in the event of a dispute. Understand that disputes happen, and act quickly when they do. Keep your emotions in check. Keeping focused on the issue and not the personalities involved will help you manage the stress of a dispute. And consider the benefit of avoiding the dispute altogether. Ask yourself whether the matter really does need to become a dispute, whether there is another way of solving the issue. This can save you money and preserve your commercial relationships. We hope you found the webinar informative. You might also find our free publication the Guide to Resolving Disputes in New Zealand helpful. Download it from the handout panel. We also have an upcoming event that may be of interest to you. It's on protecting your business's most valuable asset, your IP, and will be held on the 17th of October at 12 p.m. You can register at the link set out on the slide. We're going to answer your questions shortly. While you submit them, we'll take a minute to tell you about our membership. LegalVision's membership is a cost-effective alternative to the expensive hourly rates you experience with other law firms. For an affordable monthly fee, you can receive cost certainty and all-inclusive legal services, including unlimited document review, drafting, amending, business contracts and commercial leases. It includes unlimited advice consultations with our team of over 100 specialist lawyers, including business structuring, employment, disputes, and more, and unlimited domestic trademark registration. As a LegalVision member, you don't worry about the cost of lawyers ever again. Think of it as having your own in-house counsel. We'll take care of all the business's usual legal work so you can focus on running your business. And if you are in-house counsel, our membership is a cost-effective solution for outsourcing additional legal work. To learn more about how membership can help you, request a free consultation when the survey appears at the end of this webinar. And we'll now answer some of your questions.
Great. Look, I'm happy to answer this question that's just come through, which is, what are the advantages of mediation over arbitration? So I touched on this very briefly. The main difference between a mediation and an arbitration is that a mediation will involve an independent person that acts as a mediator. And what they are trying to do is to try and get the parties to reach some sort of compromise or agreement. So generally speaking, a mediation will take place, like in this kind of way where the parties will be invited to put their positions forward, and then they might go into separate rooms. And then the mediator will kind of try and work on the parties to get each party to understand the other party's perspective, and really try and encourage the parties to reach some sort of compromise. Ultimately, the outcome of a mediation is not binding unless the parties reach some agreement and document it. That might be in some sort of heads of agreement or a deed. But certainly the things that are said at a mediation are on a without prejudice basis, so can't be used against you, should the matter progress to court. Now, arbitration, on the other hand, is a far more formal process. I would say it's probably a lot more costly than a mediation. Certainly submissions need to be prepared, and an arbitrator sort of acts a bit like a judge, where the parties will put their positions to the arbitrator and they will decide on who's right and who's wrong. The outcome of an arbitration will be binding on the parties. So the key difference there is the mediator's not really there to make a decision. They're there to try and get the parties to work together, whereas an arbitration is trying to reach a final agreement on a particular issue. Kathryn, there's a question that you might be able to answer, which is, how can I minimise disputes when importing retail goods?
Thanks, Rebecca. So when you're importing retail goods from overseas, it can be a little bit tricky because your other party is generally in another country. So that is where it's really important to have a clear contract which sets out key terms such as what happens if the goods arrive and they're faulty. Can you return them and get a refund? Will the manufacturer credit you for any goods that are not up to standard? How do the payment terms work? Do you have to pay before you've even seen the goods, or is there a deposit and then say you pay the balance when the goods arrive and you've had a chance to inspect them? What happens if one of your customers complains about the retail goods? Are you able to then go back to the overseas party for a solution? So those types of things are what we would generally ensure we cover in a contract for the importation of retail goods. And again, really, really important to have all those key provisions set out clearly so there's no misunderstanding.
Great, Kathryn. Look, I've got a question I can answer here. How do you establish without prejudice negotiations by way of a written agreement? So just to clarify, so without prejudice negotiations, they can take place via a telephone call, correspondence like an email or a letter. And the easiest way to identify the communication as a without prejudice communication is by saying it up front. So if you're having a face-to-face meeting or you're having a telephone conference, the first thing that you want to say is, I just want to have a without prejudice discussion about these issues. Or if you're issuing an email or a letter, you would put on a heading that would clearly say without prejudice. And generally that would be accepted as confirming that that's a confidential discussion.
Thanks, Rebecca. There's another one here that I can answer. Regarding contract clauses, do you have to include a method of service of notices clause? You don't have to, because the Companies Act sets out timing for service of notices on companies. So that can be quite useful, but it is always best practice to have a method of service of notices clause in your contract, so it's really clear what happens if someone needs to serve notice on the other party. If they're not a company, that's particularly important, but generally you would include it.
Great. Look, we've got a couple of questions that are fairly specific. So there's one that's, how can I minimise disputes when employing new staff members? Look, I think that that's a question that our employment team would be best placed to help answer. So please take up the opportunity for a free consultation and we can give you some advice on that. Otherwise, we've got another question that sort of touches on the question about the difference between mediation and arbitration. So the question is a mediation's decision binding and enforceable, and how about arbitration? Just to recap, mediation is not binding unless the parties reach an agreement and document that agreement, then it would become binding. And so that's how it would become enforceable, whereas arbitration is a binding process. Okay, well, look, I think that we've addressed all of the questions that we've raised. If we haven't addressed your question, that's because it's fairly specific and we think that it would be best placed to have an individual consultation. So please take up that opportunity to book in a complimentary call with our team to see how we can help. Great. Well, look, thank you. Oh, sorry, Kathryn.
I think that's all good. Cool.
Great. Well, look, thank you for your time this morning, and we'll let you get back to your day. But thank you for joining us.
Thank you.